All right, good morning, everyone, and welcome to today's discussion hosted by the Empire Center. As Director of Public Affairs, my name is Kyle Davis, and I'm pleased that you could all be with us this morning. Before we get started, I really want to encourage everyone to actively participate by putting your questions in the chat. Cam Macdonald, our General Counsel, will be addressing questions at the end of today's presentation, so don't hesitate to put those comments and questions in the chat as we go along, so at the end we can get to them. But just first, a brief introduction of who we are at the Empire Center. At the Empire Center, we're dedicated to promoting transparency, accountability, and fiscal responsibility in government. Our research spans various policy areas, including tax and budget, healthcare, labor, energy, education, all aimed at providing citizens with the information that they need to make informed decisions and hold officials accountable. I do want to introduce our speaker today, Cam Macdonald. Cam is a General Counsel and Legal Director for the Government Justice Center. He brings a wealth of knowledge and expertise to the topic today. Throughout his career, Cam has represented clients in complex matters around the country, most recently focusing on bankruptcy and commercial litigation for a firm in Baltimore, Maryland. He has a bachelor's degree from Hamilton College and a law degree from the University of Western Ontario. And Cam is admitted to the bar in New York. Today, Cam is going to explain the appeals process in New York and delve into ongoing election-related cases before the court and their potential implications for New Yorkers. These cases are going to focus on early mail-in voting and also Prop 1 and its status on the ballot, and that is a proposal to amend the state constitution's non-discrimination clause. So as we proceed with today's presentation, remember to drop those questions in the chat, and Cam will address them at the end. Otherwise, Cam, I will turn it over to you. Thank you so much for being with us this morning.
Thank you, Kyle. I think I'm going to have to update my bio because I've now been in New York doing this work for more than 7 years. So we'll get on that for the next webinar. Good morning, everyone. So I have been following a couple issues that have been in the news that you may be interested in and interested in discussing or hearing about and getting my 2 cents for what they're worth, which may only be 2 cents. But we thought we would talk today about issues on appeal relating to the Prop 1, which is the ballot proposal to amend the Equal Rights Amendment in the state constitution. Last month, we did a webinar on its implications and so on. And today, we're just going to focus on what has been going on in the courts with that case and the challenge to its constitutional propriety as being an amendment before the voters. And then also early mail voting, which has been going through litigation since a statute was passed permitting early mail voting in 2023, June of 2023. That matter, for each of these matters, I'm using shorthand. They have longer case names, but Prop 1 is Burns v. New York, and early mail voting is Stefanik v. Hochul. So we thought we would start today with a brief primer on taking an appeal in New York. As many of you may know, New York has a complicated court system, but generally speaking, the court of original jurisdiction for most matters is at the Supreme Court. Each county has its Supreme Court, which are divided up into appellate judicial departments, appellate divisions. So when a matter is decided in a Supreme Court, it can be appealed to the appellate division for that court, and appeals there can be done as of right or by permission. Once the appellate division has ruled on a case, cases can be taken to the Court of Appeals, and the two main ways the cases get to the Court of Appeals are in appeals by as of right and appeals by permission. At the appellate division, there are appeals as of right from judgments, which can be final or interlocutory. For someone like me who spent most of my career before coming to New York and actually practicing in state courts in New York, it was a little bit of a surprise that an interlocutory order can be appealed as of right to the appellate division. So, where I mostly practiced in the federal courts, if there was a lawsuit and a motion to dismiss was filed and that motion to dismiss was denied, the case would proceed until finality, and then the issues that were raised on the motion to dismiss could be brought at the appellate level at whichever department you were in the federal courts. Also, at the Supreme Court Appellate Division, there are certain orders that a court enters that are not that can be appealed as of right. Namely, orders regarding injunctive relief, for instance, and things like that. Appeals by permission. So the civil practice rules and procedure and rules outlines the orders that can be appealed as of right at the appellate division, and then for all others that are not named under the law, appeals may be taken by permission. Again, what we're talking about today will be, in our two cases, are appeals that were done as of right to the appellate division based on judgments that were entered. So you can, in case you're not familiar with our appellate division structure, here is a map of our appellate divisions in the small, strangely colored dot down in New York City. You see Bronx and New York counties, or New York County or Manhattan. They comprise the First Department Appellate Division. The green, Long Island and some of those downstate counties, is the Second Department. In red is the Third Department, and in blue is the Fourth Department. The cases we're discussing today on Prop 1 is in the blue, the Fourth Department, and on early mail voting is the red, the Third Department. So, taking appeal in New York to the Court of Appeals, you can, as I mentioned, there are appeals as of right. There are two ways to get there on an appeal as of right. There is if there is a two-judge dissent at the appellate division on an issue on a question of law. I had a case at the appellate division a couple of years ago that was not appealable as of right to the Court of Appeals because it was two justices dissenting on the interpretation of a sentence in a Freedom of Information law request. The other way to get to the Court of Appeals as of right is if there is a constitutional ground, if there is like we have here in the early mail voting case, especially, there's a direct challenge to the early mail voting law as violating the state constitution. Now, it says appeals as of right to the Court of Appeals, but the court closely guards the gates of cases coming in. So if you are to try to take a case on appeal as of right to the Court of Appeals, you can actually do it straight from the Supreme Court if it's a final decision at the Supreme Court, or from the appellate division if there is a dissent or constitutional grounds. You will be asked by the Court of Appeals to submit a jurisdictional letter where they are going to look to see if there is a substantial question for them to address. So we will discuss that as we go forward when we discuss the Prop 1 case, what has happened recently. Another way to get to the Court of Appeals are appeals by permission. The main ways that happens are by permission of the appellate division or the Court of Appeals. That's those motions for permission for leave to appeal under that category are on final orders. And then there are circumstances where you can get permission from the appellate division to appeal where there are non-final orders. And there are two other ways to get there that are less frequent and not important for our discussions today. But this just gives you a general sense of how people get before the Court of Appeals. So on the Prop 1 case, Burns. Um, there was the court recently, you may have seen news stories that the court rejected the Burns case. It dismissed it. It did so because it determined there was no appeal as of right. And I understand from the plaintiffs in that case that they're in the process of doing a motion for permission to appeal, but I'm not sure what the schedule is on that. Now, the issue with Burns on there being no appeal as of right was that the appellate division actually ruled against them on the basis of a statute of limitations claim. So there's not actually, although there's a constitutional challenge involved with respect to how the ERA, the Prop 1 amendment was passed out of the legislature, which we'll discuss in a couple minutes. The actual question before the court, the question of law before the court, was whether or not the appellate division was correct in holding that the Burns plaintiffs missed their limitations deadline for filing their challenge. In Stefanik, oral argument is scheduled for July 30th. On that, I did actually not look to see which way it got before the court. That's not actually very easy to find out, but the reality is that this is a very direct constitutional question. I would imagine that it should have been granted on as a direct appeal because they're directly challenging the constitutionality of early mail voting in light of the constitutional provisions in Article 2 of the Constitution relating to rules about absentee voting and the manner of voting in New York. So let's get into Proposition 1 and exactly what happened there. It is a declaratory judgment action that is about the manner in which the legislature passed the concurrent resolutions necessary to put a constitutional amendment before the voters of New York. The procedure is found in Article 19, Section 1 of the Constitution. And in a nutshell, the procedure is this, that the first time a resolution is introduced in either house, in the houses, for amending the Constitution, it must be transmitted right away to the Attorney General, who has 20 days to render an opinion back to the legislature as to the effect of the amendment on other provisions of the Constitution. Fair enough. So then, after the legislature has received the Attorney General's opinion, it can go ahead and go through the process of voting on the resolution. Many of you may know that it takes two consecutive legislatures with an intervening general election in between for an amendment to pass to be put on the ballot at an election date to be determined by the legislature in the future. So in 2022, in the wake of the Supreme Court's decision in Dobbs, and also the gun rights decision in Bruin, there was a hastily called special session of the legislature where Prop 1 was introduced and passed on the same day. And at some point, several days later, the Attorney General gave her opinion saying that there was no problem with the proposed amendment with other provisions of the Constitution. The problem here is that the legislature didn't wait the 20 days. And my slide did not move. So there is a safe harbor provision for the legislature that allows them to move forward with the proposed amendment and not have the Attorney General get in the way. And that is that if the Attorney General doesn't bother to render an opinion or fails to do it within 20 days, the legislature can go ahead and and vote on the proposed amendment. The vernacular would be the Attorney General is not able to issue a pocket veto over the amendment and hold up the process. So, um, an important. So, what happened then is with the Burns case is that the plaintiffs have challenged it, and the Supreme Court in Livingston County has ruled the amendment unconstitutional because the Constitution clearly sets out a process for introducing an amendment, getting Attorney General's opinion, or waiting 20 days and then voting, which the legislature did not do. So the Supreme Court there cited the decision in late last year, early this year, in the redistricting case, where the majority in the case called Hoffman ruled that there needed to be the redistricting process restarted. And this long quote here on the page in front of me is from the Court of Appeals. It's been cleaned up from all the various quotes and so on. But the gist of what the court was saying then was that the literal language of a statute or the Constitution must control, and it is the Court of Appeals well-settled doctrine that requires the Court of Appeals to give effect to each component or provision of a statute or the Constitution to avoid a construction that treats a word or a phrase as superfluous. So what the plaintiffs correctly argued, I believe, and what the Supreme Court correctly determined in the Burns case on Prop 1 was that you couldn't read out that 20-day period before the legislature had to vote on an amendment once introduced. So at the appellate division, however, the state defendants made several arguments. First, they said, well, wait, that's not how the provision actually works. There's no duty for anybody to wait. Besides, for the last 12 years, there have been a bunch of amendments that have gone through under this process without anybody waiting. And, we did get an opinion from the Attorney General eventually and then voted again in the next legislative session. So we substantially complied. It was a horseshoes and hand grenades kind of argument here, that close enough. And hey, we've done it before, so off we go. And that provision, that was not that is meant to not give the Attorney General a pocket veto over an amendment. It means also that it just isn't important at all that the Attorney General render an opinion. If not, this lawsuit's procedurally improper because these plaintiffs have no business getting up in our business as a legislature. We're in control of our procedures within our houses, and you can't be hauling us into court to do this. There's a long body of case law they cite saying you just can't be dragging the legislature into court when you don't like what we're doing procedurally. And also, you taxpayers don't have any standing to do this, and you, Assemblymember Burns, you didn't actually assert your standing as a legislator to challenge the way we did this procedurally. So you're out of luck here too, and you didn't preserve this argument for the appellate division. Then finally, they said, all right, so even if we did everything wrong, this really should only be prospective. We're well down the path on this ballot proposal. You should just let it go to the people and let them vote, and we'll get it right next time. On that one, they were actually relying on a case called King v. Cuomo from several decades ago, where there was a challenge to the way the legislature was doing its process with passing bills and then presenting them to the governor and then saying, wait, we've changed our mind. We're going to take this thing back. And the court weighed in on that in that instance and said, well, no, that's unconstitutional. The Constitution says once it's presented to the governor's got 10 days to sign or veto the legislation. And if the 10 days passes without signature, it passes into law under the Constitution. so you did it wrong, but we're not going to open up uh, this thing to all kinds of challenges going backwards. So we're doing this prospectively. Don't do it again. Those of you who are Supreme Court watchers might uh, see a similarity between that and the Chevron decision that came out this year that just this past June, where Chief Justice Roberts basically said the same thing. Listen, Chevron's dead. We're not going to defer to the interpretations of administrative agencies where there's ambiguity in statutes. That's for Congress to address. But we're not going to go back and undo all the Chevron cases that have happened before. So what happened then is the appellate division decision did not reach a decision on the merits because it said that the statute of limitations was not met. They said that the plaintiffs needed to file their lawsuit within 4 months of the date of the first vote under CPLR 2017-1, which is the 4-month deadline to bring a proceeding against a body or an officer. Some of you may have heard of this and be very familiar with it. It's called an Article 78 proceeding under the CPLR. And what they're technically talking about was there needed to be a writ of mandamus, which is meant to cause a public officer to do a duty where the public officer has no discretion over that duty. So it's purely administrative duty. What you may be getting from here, though, is that the appellate division decision then took on and accepted a state's argument that was in complete tension. So the state argued, hey, you can't be bringing us into court to challenge how we do things procedurally in the legislature. And then the court, but then they said, but you should have challenged us within 4 months. The reality is that under the speech and debate clause, and our case law, the legislature is given great latitude to do what it does within its own house. It extends well past just what people may say in debate and so on. It protects everything that the legislature does. So I believe the appellate division case was wrongly decided because it's messing around with the independence of the legislature in violation of the speech and debate clause, telling the plaintiffs that they needed to bring an Article 78 proceeding within 4 months to compel the legislature to follow its procedures. The idea here is that the legislature was free to mess this thing up on their own, and they chose to do so. So it is I would hope that the Court of Appeals would take this up and on the motion for permission to appeal and address this decision by the appellate division. So that is the Prop 1 case. Moving along, there is the early mail voting case. The early mail voting case invokes Article 2, Section 1. Article 2 is the suffrage article of the Constitution, and there is a provision in Section 2 which discusses absentee voting and what are the requirements for absentee voting, which is you're going to be absent from your county of residence or physically unable to appear for illness or physical disability. There is also a provision in Article 2 on Section 7 provides for the manner of voting. And I'm highlighting here an element of that provision that's been in place since the founding of the state, which is all elections by the citizens shall be by ballot, provided that secrecy in voting be preserved. And that goes all the way back to 1777, where the framers of the New York State's first Constitution had the innovative idea of eliminating voice voting to have all elections done by ballot, which would be something that would tend to preserve the liberty and equal freedom of the people. You can imagine what the coercion might have been like when everybody in an election district had to show up in person and record their vote by voice. I think that the histories are replete with violence at those types of elections and lots of coercion. So They did realize that, however, the framers then did realize they were doing an experiment. So they gave the legislature authority to abolish any acts that they put in place to put together voting by ballot if they happened to find that it wasn't a very good way to do elections. And they were mostly interested in finding the way to have people vote in elections in New York in the way that was most conducive to the safety and interests of the state, including, the liberty and equal freedom of the people. So by 1821, however, at the Constitutional Convention in 1821, the delegates there had concluded that voting by ballot in secret was a pretty good idea. So they made it a constitutional provision that all elections by the citizens shall be by ballot, except for town officers. And we don't need to go into the debate about that. So then, secret ballot voting by ballot in secrecy has been part of the fabric of New York since 1777, but it came under some pressure in the Civil War with many, hundreds of thousands of soldiers out of state during the Civil War or away from their voting districts. So they amended the Constitution to allow for soldiers to have file an absentee vote, but I was interested in how it was done, in that it was really done to kind of preserve all of the formalities of voting in person by secret. So first of all, the soldier, wherever he was, needed to execute a sworn instrument appointing the elector. And that instrument needed to be sworn in front of an officer. The appointed elector had to be from the same town or city. And then the soldier would send a ballot sealed in an envelope marked soldier's vote. And on election day, the appointed elector would show up before an election inspector and would open the ballot there and then and drop it into the box. That was sort of the status quo for absentee voting until after World War II. But in the interim, there was a change to the way they would do the manner of voting. In 1894, there was a constitutional convention where there was extensive debate about the idea of people voting by machine. There were great misgivings about, the reliability of machines, people messing around with machines. Like, some things just never change, right? You've got 1894, them worried that somebody will rig the voting through messing with the machines. And in 2020, we have concerns about voting machines being sabotaged or played with. So the entire debate was what to do about voting by machine. They decided that, in 1894, progress was progress. So they added this provision that said that voting shall be by ballot or by such other method as may be prescribed by law, provided that secrecy in voting be preserved. So you see this thread running through that secrecy needed to be, the importance of secrecy and election integrity, and this, sort of incremental change to the laws to add these voting machines to get with the times. So voting by machine became constitutionally okay, and then back to absentee voting. Not much. Things really started to change after World War I. So in an amendment in 1919, the Constitution was amended to add people who were out of their election districts due to business travel, and then there were displaced veterans in homes away from their residence and that sort of thing. So they amended the Constitution to allow for that. And then there were the disruptions of World War II, and they kind of further expanded the categories of people who could vote absentee. And all of this from 1919 through 1945 was really recognizing that the world had changed quite a bit and people were much more mobile, away from home much more often, and that sort of thing. So there needed to be some reasons for absentee voting. And then in 1963, the legislature was given the power to define what were valid absentee excuses, but as we saw earlier, the provision still provided that you had to be physically unable to show up at the polling place or physically absent from your county of residence on election day. So that's all well and good. There's been the absentee voting, no excuse absentee voting. And then what we had in 2020, of course, was the pandemic. And, mail voting was allowed to happen, which then led to there being a 2021 ballot proposal that put before the voters that essentially would amend the absentee balloting provision to result in no excuse absentee ballots. So this is the form of the amendment that was that the people voted on, and much really to, I think, everyone's surprise, that that ballot proposal was voted down. Not to be discouraged, however, the legislature in 2023 passed early mail voting legislations. Like, let's just change the name of it from no excuse absentee voting to early mail voting, and this thing will go through. Everybody will not be the wiser. So, essentially it says a registered voter may apply to vote early by mail under the elections law in any election conducted by the Board of Elections in which the voter is eligible to vote. So they basically completely rejected the will of the people from just over a year and a half earlier. So the Stefanik plaintiffs promptly challenged the law, and at the Supreme Court decision really focused on what was done in 1894 when they were debating machine voting, and said, okay, so there's or by such other method as may be prescribed by law. According to the Supreme Court in Albany County, that meant that voting was open to mail-in voting way back in 1894. Never mind the fact that almost 130 years later, the legislature still thought the Constitution needed to be amended, and never mind the fact that there is Section 2, which has the absentee voting provisions that are going to be kind of completely read out of the Constitution by that. So the plaintiffs appealed to the appellate division, and the appellate division went a different direction. The appellate division focused on Article 2, Section 1. It was amended in 1966 to be this much more concise provision. It was brought down from more than 300, a sentence that was more than 330 words to these 32 words. And it did more. It changed age of voting, residence, and the length of time needing to be a resident before a person is eligible to vote. What was key in that rewriting of that very long provision that I've cut down here is that it removed this provision that said that a citizen shall be entitled to vote at such election in the election district of which he or she shall be at the time be a resident, and not elsewhere. So the appellate division concluded from the removal of that provision in 1966 that mail-in voting is perfectly constitutional. But I recently found a report that was done for the 1967 Constitutional Convention for a temporary New York State temporary commission on the Constitutional Convention that looked into the issue of suffrage and voting. And that in that report, it weighed two absentee voting approaches. It said, first of all, we could just make this an administrative matter over which the legislature should have full discretion, or we could continue to place limitations on the legislature's power to permit absentee voting in order to protect the integrity of the electoral process. Now, this report was dated February 1967, just months after the 1966 amendment changing Section 1 was passed by the voters. And so clearly, constitutional experts at the time did not think Section 1 had changed the status quo on absentee voting. In fact, they dropped a footnote in the report saying, it is possible that the 1966 amendment removing the election district residency requirement gave the legislature unrestricted discretion over absentee voting. But this interpretation, however, makes Article 2, Section 2 superfluous. And that gets us back to where we were before on the Court of Appeals' recently stated standard for constitutional interpretation, that it's the court's well-settled doctrine that requires them to give effect to each component provision of the Constitution to avoid a construction that treats a word or phrase or provision, I guess, superfluous. So it's my belief that if the Court of Appeals is going to be consistent on its constitutional interpretation, that the innovative approach taken to Section 1 of Article 2, permitting mail-in voting, that nobody understood to be the case for almost 60 years, should be rendered incorrect, and that early mail voting should be ruled unconstitutional. So that's my take on things, my sort of summary of the issues. If anybody has any questions, I'd be happy to try to address them.